All right, let's get into this. Today, we're breaking down a legal battle that all started with one homeowner who just wanted some shade for his patio. A simple request, you'd think, right? Well, this seemingly small issue absolutely blew up into a multi-year fight with his homeowners association, and the whole thing ended up hinging on one single, really confusing sentence in the community rulebook. So here's the roadmap for this wild story. First, we'll start with that initial quest for shade. Then we'll follow the legal fight through some major setbacks and a surprising second chance. Then comes the twist. And trust me, you won't see it coming. From there, we'll zoom in on the fine print, the one clause that decided everything. And finally, we'll land on the judge's final decision. Okay, so let's set the scene. Our story is all about a homeowner named Charles Mandela. He lives in a community called Ridge Estates, and he wanted to do something pretty basic: build a patio shade in his backyard. Seems reasonable enough, doesn't it? I mean, if you've ever dealt with an HOA, this probably sounds a little too familiar. But for Mr. Mandela, his simple request for a little shade didn't just get tied up in some red tape. No, it sent him down a long, winding road that led straight into a courtroom. And we're not talking about a quick disagreement here. Just look at this timeline. This was a marathon. We're talking years of effort. From that very first, no way back in February 2018, all the way to an official legal hearing in January of 2021. Just wow. So after all that back and forth, years of it, things finally get serious. The whole dispute lands in front of an administrative law judge. Now, this is a neutral third party whose whole job is to sort out messes like this one. Mr. Mandela's argument was pretty straightforward. He believed the HOA had unfairly and improperly denied his plan. But at that first hearing, it was a total bust for him. The judge actually sided with the HOA. But he was not ready to give up. He filed an appeal, arguing that the decision was, quote, arbitrary and wasn't really supported by the facts. And you know what? It worked. His request for a brand new hearing was granted. He got a second chance. Okay, so everyone's gearing up for round two. The lawyers are prepping, the arguments are being refined, but this is where the story takes a truly bizarre turn. Just remember, this entire fight, all the time, the stress, the money, it was all about getting a patio shade approved. Get this. By the time everyone showed up for the second hearing, the HOA had already approved the patio shade. I'm not kidding. Sometime after they won in court the first time, but before the second hearing could happen, they just gave him the green light. So, what's the point now, right? If the shed is approved, case closed? Well, not for Mr. Mandela. You see, for him, it wasn't about the shed anymore. It was about the principle of the thing. It was about whether the HOA had followed its own rulebook when they denied him in the first place. So, forget the patio shade for a second. That's not even the main issue anymore. The entire legal case, everything, now boiled down to one single crucial sentence, buried deep in the HOA's governing documents, Article 10.3. Mr. Mandela's whole argument now rested on a specific deadline. He went all the way back to his official request from August 2019 and said, hey, you guys violated your own rules because you never gave me a written response in the 30 days you were supposed to. And here it is. This is the exact wording from the rulebook that started this whole firestorm. It says, if the committee doesn't act within 30 days, the project is deemed disapproved. So, what does that actually mean? Well, as you're about to see, both sides had a completely different idea. And here you see it, clear as day. Two people can read the exact same sentence and come away with two totally opposite conclusions. For Mandela, the HOA's silence was them breaking the rules. But for the HOA, their silence was the response. It was an automatic no that was baked right into the bylaws. So you've got this messy, confusing rule. How on earth does a judge make a final call on this? Which side is right? Well, for starters, the judge basically admitted the rule was a total mess. He used the term unartfully drafted, which is really just a polite legal way of saying, wow, this is really poorly written. So he saw the confusion, but he still had to interpret what the rule was intended to mean. So here's how the judge broke it down, and it's a really important two-step logic. First, he agreed with the HOA. He said that a non-response within 30 days is, in fact, a denial. It's an automatic no. And second, he pointed out that the rules say after you get that automatic no, your next move is to formally ask for a meeting, a step that Mr. Mandela had never taken. And believe it or not, that was it. That was the ball game. Even though the rule was confusing, and even though the shade eventually got approved anyway,
The judge had to conclude that, technically, the HOA hadn't broken its own rules. Mr. Mandela's appeal was dismissed.
So, after all that, what are we supposed to take away from this? Well, this whole saga has some huge lessons for anyone living under an HOA. Number one, the exact specific wording in those documents matters more than anything. Number two, a deemed denial, an automatic denial, is just as official as a letter in the mail. And number three, if you do get into a dispute, you have to follow the appeal process to the absolute letter. And that really leaves us with one final thought, something for you to consider. When was the last time you actually read your own community's bylaws? Are they clear? Do they protect you? Or are they maybe a little unartfully drafted, leaving you open to an interpretation you never saw coming? Because as Mr. Mandela's story shows us, knowing that fine print, well, it can make all the difference in the world.